After 25 years in policing, I reached a conclusion I can't ignore. Civil rights litigation doesn't just have a failure to train question. It has a police training systems question. And I don't think those are the same conversation. Over the past month, I've been quietly listening to conversations among experienced civil rights attorneys from across the country. I've heard discussions about deliberate indifference, Monell, qualified immunity, discovery, experts, affidavits, settlement strategy, municipal liability. Exactly the conversations I would expect. But I also noticed something. Almost every discussion begins after the incident, after the police shooting, after the arrest, after the use of force, after medical care is denied, after someone is injured, after a constitutional right is allegedly violated. That isn't criticism. That's litigation. Litigation begins with an incident. Police training systems do not. A police training system already exists before the first radio call, before the first citizen encounter, before the first supervisor arrives or commander, before the first report is written, before the first lawsuit is filed. That's what keeps my attention, because when I hear the phrase failure to train, I find myself wondering whether we're all talking about the same thing. Failure of what? A class, an instructor, a lesson plan, a training record, or an institutional police training system. Those are not interchangeable ideas, and I think that distinction matters. When a police department says, quote, the officer was trained, end quote, most people naturally think the conversation has moved forward. I'm not so sure. Because being able to point to training is not necessarily the same as defining the police training system that produced it. Different questions. One asks whether the training occurred. The other asks what institutional system existed before the incident. And I rarely hear that second question. Not because attorneys aren't asking good questions. They are. They're asking exactly the questions lawyers should ask. My observation is different. I think we've become, as a society, so familiar with the phrase failure to train that we sometimes assume everyone means the same thing. I'm no longer convinced we do. For years, police organizations have produced lesson plans, training bulletins, PowerPoint presentations, attendance records, policy acknowledgments, annual certifications. And those documents are vital. They're a part of the story. But I don't believe they automatically define the institutional police training system they are presumed to represent. Documentation and definition are not the same thing. And if they are not the same thing, perhaps litigation has been moving too quickly from records to conclusions. Here's what I find interesting. When attorneys discuss deliberate indifference, they're often evaluating what happened. When police leaders discuss training, they're often describing what was delivered. Those are important conversations, but I keep returning to something that sits between them: the police training system itself, not the paperwork, not the curriculum, not the records, the institutional function. Because police officers do not perform inside lesson plans. They perform inside organizations. Organizations that establish expectations long before an officer ever steps onto the street. Organizations that decide how constitutional policing will be prepared, reinforced, evaluated. Those institutional choices exist before the incident. They exist before discovery, before depositions, before experts, before litigation, whether anyone stops to define them or not. And that's why I think this conversation is crucial. Not because every case involves a defective police training system. It doesn't. Not because every constitutional violation can be traced to institutional preparation, because it can't. But because the police training system is often treated as though everyone already knows what it is. I'm not convinced that's true. In fact, I think one of the most important questions in police accountability has become one of the least defined. What exactly is the police training system? Not the records, the compliance file, the annual in-service calendar, the system. Because if we never clearly define the institutional system, there may be years debating whether it failed without first agreeing on what it is. That isn't a legal opinion. It isn't litigation strategy. It's an organizational observation. One that has stayed with me after 25 years in policing. One that has stayed with me after serving in one of the largest police departments in this country in their Training and Education Services Bureau. And one that continues to shape every question I ask. I'm Tom Loglisci. Thank you for listening to Police Praxis Audio Briefings.